think that the department is looking to continue to advance their FCPA enforcement program in 2010 and 2011. Mark Mendelson is going to be leaving the department, but I think that they're looking to fill his shoes and to take the enforcement program to the next level. I would expect, consistent with the remarks by Assistant Attorney General Lanny Brewer, that you are going to see more industry-type investigations like with the pharma and medical device investigation. I think they're going to be looking for other opportunities to have these horizontal-type investigations where they're leveraging off of investigations against one company to also target competitors. A FCPA problem in an M&A deal could be a deal killer, but it doesn't necessarily have to be. It's really going to depend on the scope of the problem. And what I usually recommend that clients do is to take a step back and look at whether or not the corruption issue changes the value of the deal itself. So if it's a pervasive corruption problem and you have a company that has only generated business based on the fact that they've been paying bribes, that company is actually intrinsically less valuable than it would be had it not been paying bribes. So once you strip away the corrupt contracts, permits, licenses, what do you have left? And is it something where the company has any value, or are you just buying downside risk? I think that's important to evaluate from a business perspective as well as from a regulatory perspective. I think companies are banding together to learn about best practices and figuring out ways to share with each other without creating other issues, other problems, and also with not disclosing proprietary information or information that relates to their M&A intentions. But I think that it's an interesting, companies are looking for interesting new ways to identify best practices and to hold themselves above the bar and give themselves comfort that they are meeting or exceeding the industry standard. I don't know how much companies will be using trade organizations, but I think it's an interesting concept that I've heard about, and I think you'll probably see a little bit more of. I think the I don't know what I don't know it makes people nervous now because of the government's view of your responsibility over internal controls. And it's not sufficient anymore to say, I don't know what I don't know. I think that control functions like a general counsel, like a compliance officer and senior management, audit committees, boards of directors, are being held to a higher standard, and they're being expected to take responsibility for these compliance programs, to make sure that the compliance programs are effective, and to make sure that they understand what's going on in their backyard and that the internal controls are sufficient to pick up improper or problematic conduct. So if they put their heads in the sand in this day and age, I think it raises additional risk. And I think for a lot of general counsel and compliance officers, that's the issue that keeps them up at night, is really making sure that they have a handle on the controls and that they are objectively effective.